Case on this morning's docket, that is case number 110200 in the matter of Jeffrey M. Goodwin.
May it please the Court, Kate Baird appears on behalf of the Disciplinary Administrator's Office. Chief Justice Nuss, may I reserve 2 minutes, please, for rebuttal?
2 minutes is granted.
Thank you. In this matter regarding the respondent, Jeffrey Goodwin, I think as a bottom line, it poses the question, what do we do with a lawyer that doesn't want to be a lawyer? No exceptions were taken to the recommendation of the panel, the conclusions of the panel that there were multiple rules violations in this case. They recommended an 18-month suspension and a 219 hearing, which is notable when the respondent at the hearing requested that the panel indefinitely suspend his license. The Disciplinary Administrator's Office, at the panel hearing, requested disbarment or indefinite suspension. There was testimony. I'll back up a little bit. The respondent was admitted to practice in 1997, and he testified at the panel hearing in June of 2013 that he didn't like the practice of law, that he had never liked the practice of law, and that he hoped that he never had to practice again. He did then follow that comment with, and that's at Record Volume 2, page 67. He followed that with the request that they consider.
Well, we don't sanction for bad attitude, do we? We have
don't.
to sanction for the misconduct.
And I agree with that, certainly, but I do think the attitude is appropriate to consider as we determine, A, the sanction, and B, whether there's a risk of harm to the public. If we allow, there are a lot of lawyers probably that may unfortunately find themselves practicing out of necessity rather than out of a genuine interest in practicing law. Unfortunately, that may be the case. In this case demonstrates what I would suggest is harm as a result of that. I argued to the panel that this respondent stopped practicing before he took the $500 retainer from his client, the complainant in the case, that he, in effect, had already stopped functioning as an attorney. And that's where the risk lies in allowing this respondent to continue practicing. I agree certainly that we don't, and the panel made note of that in their report, that it's appropriate to sanction conduct, not attitude. I would suggest that both the conduct in this case as well as the attitude warrant serious sanction by this court.
Why doesn't he just give up his license?
Well, I wonder about that.
Guess we'll ask him.
It appeared from his testimony that was in the event his position changes, that he asked for indefinite suspension in the event he decided at some point to ask to be reinstated. But I can't answer that question, Justice Beyer. He, again, took this retainer from this complainant. He didn't participate in the disciplinary process. He filed an answer at the 11th hour and appeared at the panel hearing articulating that I don't like the practice. I don't have an intent to practice again. I hope I never have to practice again. And the panel pointed out that as a condition of a 219 hearing, his attitude would have to change, or he would have to demonstrate a change in attitude. My recommendation continues to be disbarment or indefinite suspension based upon the conduct The aggravating factor, the panel also accepted and found as an aggravating factor prior discipline, which I would advise this court included, was based upon a failure to appear at a jury trial in 2007. My recommendation was based upon failure to participate in the disciplinary process in any appreciable sense. And what was characterized in the report as a distaste for the profession, I would argue to the court was almost a disdain for the profession. And the shorter suspension period poses one risk that I see, and that is a petition for reinstatement out of necessity again, rather than out of choice. That if this respondent finds after a period of time that economic factors or for whatever reason that he has to ask this court to be reinstated, that we need to be confident that it is because he wants to be a part of this profession, not because he has to.
I don't understand that, because your 219 hearing is going to be your safeguard on that, isn't it?
It's going to be a safeguard. I would suggest that this court consider requiring as a condition of 219 that the hearing panel consider not only whether or not the attitude has changed, but a safeguard, a plan. Perhaps a sense that the respondent has considered that he took this path once before and it led him to appearing before the court, and that he has a plan in place to identify those signals, those factors that will allow him to address the issue before it gets to that point. And I would certainly hope that a 219 hearing would be sufficient to address that issue. I don't have additional comments unless the court has questions of me.
Well, the panel had recommended that the respondent undergo an attitude adjustment prior to appearing before the reinstatement hearing.
Right.
And could you give us any more ways that that he could demonstrate that to the panel and to your satisfaction? You keep talking about showing a plan that he has, and I'm kind of curious how he's going to do that.
Well, I would hope that he could, before he, if he chooses to seek reinstatement, look back and identify what led him to the point. What signals might have been in place, what factors may have contributed to his reaching the point where he did not want to be a part of this profession. If it were practicing as a solo practitioner or other instances in his practice that clearly led him in 17 years to a point where he just didn't want to be a part of it anymore. So there may be a change in a year or in a year and a half where he decides, okay, I do want to practice again. But in order to protect the public, I would hope that we can address the question of whether or not he looked back to determine what led him to the point that got him here in the first place.
All right, thank you. Any further presentation? Counsel, any further presentation?
Oh, I'm sorry. Nothing, Justice Ness, unless there are questions.
Questions? All right, thank you.
Hey, police court, Mr. Goodwin appears in person to address the situation that Ms. Baird had spoke of. I can promise you, I don't want to practice law anymore. I never wanted to in the 17 years that I did, but I will tell you this. All the people that I represented, mostly in criminal defense, I represented to the hilt of my ability. I acquitted many of them. I never let my distaste of the practice of law interfere with my ability to represent those people or represent them to the absolute ability that I could. They were always defended. Every
Except
one
for
of
this
them.
client.
Well, this client was, yes, in a way. This client was a diversion eligible client. It was a juvenile client. Essentially, all I had to do was sign a piece of paper. That's it. That's all this client's representation had. I had reviewed his entire case. I had done everything that I would have done for any other client. And in fact, quite frankly, I was a public defender for Wyandotte County in the juvenile system for my entire career. On the days, as I explained to the panel, those days are almost like, I don't know if you watched MASH, it's ER almost when I walk in. There are 2 attorneys and there are almost 4 hours of cases. And sometimes you just ER it. You go through, you look, you make snap decisions. It's one of the things that I'm actually really good at when I practice law, was the ability to define a situation, to find the ramifications of that law or the actual outcome, and make a recommendation within minutes, really, to be honest.
Well, Counselor, I had the juvenile offender contract for a while, so I know what you're talking about, but I didn't refuse or I didn't fail to appear in court. And did I get this wrong? But your client and his father were at court at least once and maybe 2 times, and you weren't there?
That is correct. No, I'm not doubting the facts whatsoever in this matter.
Could you answer the question that Ms. Baird started this case off with, and maybe you can provide an answer? What do you do with a lawyer who doesn't want to be a lawyer? Could you answer that question?
Actually, that is a good question. I was actually thinking about that answer when she said
What's
that.
your answer?
I don't know, to be honest.
What about surrender of your license?
I don't want to surrender my license just because I don't want to. I don't practice law anymore. I don't. I have not entered the courtroom since February 15th of this year when I sentenced an individual to probation. I am, quite frankly, I am a volunteer track and field coach, which is what I do. I coach. And ironically,
I hope that's what you want to do.
that's what I want to do. And I ran track for Mizzou. I know that's a very horrible thing to say, that I ran track for the University of Missouri in this state. Ironically, I was in Lawrence, Kansas in the indoor track and field facility Saturday when Mizzou was playing the SEC game, biggest game of my life probably to watch. But I helped coach 3 kids, 3 freshmen to their school record in their PRs. That's what I do. My mom was a coach. That's what I do. I coached at Mizzou. I spent 17 years practicing law, and I will say this, I gave the same effort that I gave to that coaching that I did that law. But after a while, I realized I wasn't doing what I should do in terms of representation or coaching. I quit. I did. I quit. In fact, I refused to take cases because I knew that I would not be able to represent those people to the ability that they needed to be represented.
But you acknowledge you didn't finish the representation for DT.
This individual, yes, but
And you agree that, or do you admit that you did not return the $500 retainer?
no, I did return it. It hasn't been paid. They're a whole.
When was that done?
I'm sorry, October, I believe. October 22nd.
This was after the hearing?
Yes. So they have been made whole. So
The problem we've got to wrestle with here is, we can put in context the ethical problems with other cases and come out with a result, but we also have to have, sometimes you find even minor ethical violations that indicate deeper issues in terms of public safety, and the ability of clients to be able to go to a lawyer and get the proper service. And if we leave you in a situation where you have your license, what protects the public from you deciding you don't want to help the next person that comes along the way you failed to help these people?
Well, first of all, I would say I didn't necessarily fail these people, only in the fact that they got the exact thing that I had advised them completed. Secondly, I don't advise people, period. I mean, I guess you would have to take my word for it. And obviously, if I came back to practice law in the state of Kansas, I would have to go through the hearing. And as such, there would be some other individuals that allowed me to practice law in the state of Kansas. I mean, I can tell you right now, I do not ever plan to come back and practice law in the state of Kansas.
So you're all right with a suspension of your license and a 219 hearing to return?
Yes,
Okay.
absolutely. That's my whole point. I have no problem with what the board recommended.
Are you still no problem with indefinite suspension as well?
If that's what the court recommends, that's fine.
Well, it was indefinite suspension or disbarment from the,
Well, I guess the only thing I would say is that I rose to the level of Phil Klein when you recommended that to him too. So, I mean, I know the board didn't believe it necessarily, but I don't like practicing law. I was good at it, but I don't like it. So, I'm not coming back, is what I'm saying.
In light of the allegations against you, what I'm about to say is a very minor point, but I would like to find out on the record, why were you late to this morning's proceeding?
I simply traffic. I came
And to
from
follow
Kansas
up
City.
on your parallel profession, I'm kind of curious, what happens when somebody in a track meet doesn't show up for their event on time?
Well, I mean, normally they're disqualified.
All right. You have any further presentation for us, sir?
I do not, sir.
Any more questions? Thank you.
Thank you.
You'd reserve 2 minutes for rebuttal.
Chief Justice Ness, I would waive rebuttal unless there's a question of the court.
Any further questions? See none. Thank you both for your arguments this morning. Court will take this matter under advisement.